Your Honour, my name is Payne, first initial M, and I appear for the applicant Johnny Wishbone. Your Honour, I wish to raise with the Court the issue of admissibility of evidence, which I believe needs to be addressed by Your Honour prior to any further proceedings in this matter. Your Honour, the circumstances are as follows. On the 23rd of June 2016, my client, an Indigenous juvenile, was located by police walking out of the curtilage of the property at 2 Smith Street, Suburbia. Police conducted a search of my client and subsequently placed him under arrest on the charge of breaking and entering and stealing. Following the arrest, Your Honour, my client was placed in a police vehicle and driven around the surrounding neighbourhood, during which the police questioned my client about his involvement in further offences. It was during this time that the police alleged that my client made a number of admissions in relation to these other offences. My client was then taken to the Suburbia police station, where he participated in an interview. Your Honour, my issue of admissibility is based on the following. My client's rights, as legislated under the Police Powers and Responsibilities Act, were obstructed. The procedures for interviewing juvenile Indigenous suspects was flawed. And that police, on the 23rd of June 2016, were negligent in the performance of their duties and their duty of care. Now, Your Honour, as I address the aforementioned items and their impact on the evidence in relation to the charges, I ask Your Honour to turn your mind to Bunnings v Cross, specifically the probative value v prejudicial value and the exclusion of evidence. Your Honour, Section 431(1) of the Police Powers and Responsibility Act states this: a police officer must, before a relevant person is questioned, caution the person in a way required under the Responsibilities Code. The Police Powers and Responsibilities Regulation, specifically Section 26(1), give that a caution must include the person's right to silence. It is further accepted practice, Your Honour, that the person must demonstrate an understanding of the caution, generally by means of explaining to the officer what that caution means to them. Now, according to the arresting officer, my client was not afforded a caution at the time of his arrest, nor was he afforded one during his time in the police vehicle whilst being driven around and questioned. As previously mentioned, Your Honour, it was during this time that it is alleged that my client made a number of admissions which were not audio recorded by police. Your Honour, as an Indigenous juvenile male, there is clearly an instance of gratuitous concurrence here. Now, if I could indulge the Court with a short explanation, gratuitous concurrence is when a person appears to assent to every proposition put to them, even when they do not agree. For many Indigenous people, Your Honour, using gratuitous concurrence during a conversation is a cultural phenomenon. Additionally, it is widely recognised that people who are in a position of powerlessness when confronted by alien institutions and authority figures may adopt a strategy of always agreeing, regardless of the truth of the matter. Your Honour, I will now discuss my client's interview at the police station. Section 418 of the Police Powers and Responsibilities Act states the following: before a police officer starts to question a relevant person for an indictable offence, that police officer must inform the person that they may telephone or speak to a friend or relative to inform them of their whereabouts, and to request their attendance at the interview, Your Honour, but furthermore, to also contact their lawyer to attempt to arrange for them to be present as well. My client was not given any opportunity to contact any family member, friend or elder, and was instead led to an interview room where he was told that an unidentified social worker, towards who he had no cultural ties, was going to be his support person. Your Honour, I think it is important to draw attention to the behaviour of the social worker, who behaved in a manner inconsistent with that expected of a legal aid representative. Upon meeting my client, the social worker did not advise him of his right to silence, did not ask if he needed anything explained or even if he understood what was happening. Instead, Your Honour, she instructed him to answer the questions asked by the police. This, Your Honour, is a gross violation of my client's rights, and I will now explain to the Court the concerns with the police investigation. Following my client's arrest in the front yard of the premises, it appears that the investigation has been left wanting in being able to adequately demonstrate the following to the Court: a sufficient level of suspicion to stop and search my client for property stolen from a break and enter at the said premises. Police, Your Honour, originally attended the premises for what can only be described as a trespass. Now, Your Honour, without any further evidence, the officers detained my client and searched him. It appears on merit that the officers' prejudiced attitude towards young black males hindered their ability to make a sound decision based on situational awareness. Secondly, the identification of my client's age and identity prior to any search was not undertaken. Your Honour, thirdly, where they established my client's level of understanding, English language and his social awareness. And finally, that the police officers failed in their duty of care of a juvenile Indigenous male as to any levels of intoxication or drug influence, mental impairment or any other medical conditions. Your Honour, I would now like to address the admissibility of the alleged admissions of guilt and the recorded interview. Both of these interviews were conducted inconsistent with the regulations set down by both the Police Powers and Responsibilities Act and the Police Powers and Responsibilities Code. Now, Your Honour, Bunning v Cross clearly defines a judge's power to dismiss evidence that has been improperly gained by police. The defence's case relies heavily on the alleged admissions to police in the police vehicle and the ensuing interview at the police station. Whilst to make this evidence inadmissible would weaken, if not terminate, the prosecution's case, to deny proper process and ignore a person's rights would set a dangerous precedence, Your Honour. Therefore, I ask Your Honour to balance the probative value of this evidence and how it was obtained against this prejudicial detriment to my client in a fair trial. It is clear that the police ignored my client's rights as legislated and were extremely negligent in the performance and application of their duties. It is my submission, Your Honour, that all the charges against my client arising out of the alleged admissions and record of interview be dismissed. I further submit, Your Honour, the only charge to be contested here today is that of trespass. As Your Honour pleases.